Hi, my name is Catherine Simmons, and I am here today representing the AU Hospital. We are here today because the AU Hospital has been charged with releasing the plaintiff Jennifer's PHI information without her proper consent. Currently, there are 11 HIPAA-defined permissions that allow for release of the PHI. Under these 11 positions, the AU Hospital has the right to use or disclose the information obtained in the patient's PHI for any treatment, payments, or other healthcare operations. As a healthcare facility, the AU Hospital's physicians may have to use the information on the patient's PHI with another physician in order to continue treatment. For example, if a patient comes into the AU facility to receive treatment for cardiac arrest, the physician tending to the patient may release the patient's information to a cardiac facility for further treatment and diagnosis. In addition, the physician in the AU hospital may disclose patient's PHI in order to obtain laboratory results. The information obtained on the PHI is often important in order to obtain the correct results and testing procedures for the patient under the AU hospital standards and protocols. For example, using the same situation of the patient being treated for cardiac arrest, the physician may order an EKG and additional blood work and cultures to determine any other underlying causes. The PHI may be needed to obtain information about the patient's current prescriptions, if any, recent diseases or illnesses, the patient's height, weight, age, and gender, to conduct accurate readings. In addition, the AU hospital has the right to release the patient's PHI information to file the patient's insurance correctly and discover the patient's co-payments. All of these situations in which the AU hospital will release the patient's PHI without needing consent from the patient. Furthermore, healthcare facilities may be required to release information for the protection of the public and other individuals. Some of these situations that need the patient's PHI are the public health authorities, in which are required by law to receive information that helps protect the general public from diseases that need to be controlled. Some of these diseases that need to be controlled are TB, swine flu, West Nile. For the same purpose of the PHI information released to the health authorities, allows for there to be accurate information obtained on the patient's births, deaths, or for the purpose of public health investigations. In addition, the AU hospital is required by law to release any information about a patient that has been infected with an infectious disease. This is required by law to protect the majority of the public and give the opportunity for individuals that have become contaminated to get tested or treated at a healthcare facility. It is not required that the AU hospital has to ask permission for these situations in order to release information in regards for the CDC to keep the public safe. In regards to the information discussed in the case involving Ms. Jennifer, the AU hospital has concluded that the facility did all that was necessary in order to provide the information to the courts based on the subpoena. When the AU hospital received the subpoena, there was not a court order or a summons included. Without this information, the healthcare facility can release some of the information about the patient while excluding certain types of identification within the PHI. This form of transfer of the patient's PHI is known as dislocation and is not considered to be protected under the HIPAA regulations, and therefore the AU hospital does not have to inform the patient. In addition, if the subpoena was requested in a case based on the information discussed earlier in regards to the hospital's right and laws regulating the release of information, the patient may not have needed to be informed of the information being used. That concludes my case, and thank you for listening.